Hi everybody, it's Coach Collard here with AZSSTV.com. Coming to you today with a conversation around notes and deeds of trust. And it's important for you, the homeowner, to know about this simply because it basically affects how we handle the transactions in a short sale situation, how we handle the transactions in a foreclosure situation, why you might consider something like a deed in lieu and how a short sale is probably generally better than that or a better option for you. It affects a lot of things for you, the homeowner here in Arizona. So per the state statutes in Arizona, we are a note and deed of trust state, not a mortgage state. So although everybody talks about, hey, I got to pay my mortgage, in Arizona, you likely, unless you have a mortgage that was in place before like 1975, you probably don't have a residential real estate mortgage. You have a residential real estate note and deed of trust. And the note is basically an IOU. It's the 4-page document that you sign at closing when you buy a home and get a loan that says, I owe you the money to Mr. Bank. Basically, it's an IOU. The note goes along with what's called a deed of trust. And the deed of trust is a security instrument which basically creates the lien against the property. Does that make sense? So the lien, the deed of trust, or the security instrument, goes with the note, which is the IOU, and those together make up what we all consider to be a mortgage. So in the state of Arizona, being the fact that we are a deed of trust state, the deed of trust process, when a person goes delinquent, and it says this in the deed of trust, when a person goes delinquent, we have a non-judicial foreclosure process or non-judicial trustee sale process. It's not even really a foreclosure in Arizona, it's more of a trustee sale. And the deed of trust outlines the parameters of the lender, which is the beneficiary of the deed of trust. It outlines what they can and can't do. And basically in Arizona, it says, upon default, the lender has the requirement to notify officially in public records the homeowner of default. Now, technically by law, they can do that when you go 30 days delinquent. We very seldom see them file notice of default public records wise until about 90 or 120 days, which is 3 to 4 months. Once they file that notice of default, it's public record that they're now in the process of pursuing the trustee sale, which would then be scheduled. Let's say they had a notice of default filed against me today, August, what's today, the 10th? August 10th. Or actually it'll be next Tuesday, so, or whenever it is. Let's just say today, August 10th, when I'm filming this. So 90 days from now, or 91 days from now, they would actually schedule with a trustee, being an attorney, a specialized real estate attorney, they would schedule a trustee sale for my property, and that's actually what we call foreclosure. So the actual foreclosure piece happens in a moment in time when the property's bidded upon or attempted for sale at a trustee sale auction. All of that stuff in between there is just waiting time, and it's when you, the homeowner, can reinstate the loan and do all sorts of stuff. Now, here's one of the nuances I mentioned before in one of the previous videos about communication issues with the lender. I'm going to encourage you guys, anytime you make a deal with the lender, if you're attempting to reinstate your loan, make sure you get things in writing, not only when you pay or reinstate the loan, but make sure that they put it in writing that they'll do a certain thing if you catch them up. We've heard stories out there, Ryan, and it's pretty tough. We've heard stories out there, and this is why we're huge proponents of short sales, to actually clear the property. But some of those stories manifest the following. A homeowner will be talking to a bank, and the bank will be within the within the 90-day period after notice of default before trustee sale. And the homeowner will want to reinstate the loan. And so the bank will say, well, you owe this much, you're 4 months delinquent, so you owe $8,000. And the person will pay that $8,000, but for whatever reason, when they were notified of that $8,000 before they paid it, they weren't notified of attorney and trustee sale fees and interests and things like that were added onto it. So they caught up the $8,000, but the loan wasn't fully reinstated because there was still extra monies owed. So, and that's just a simple communication issue. Sometimes it's the lender not telling the homeowner. Sometimes it's the homeowner not knowing to ask. Sometimes they may be speaking similar language but not understand each other. So there's a million reasons why that happens, but you just got to be aware of it. So ultimately this video is around the note and the deed of trust, and I want you guys to understand that as the state of Arizona being the note and deed of trust state and in creating that trustee sale process, it's what's called non-judicial. So it's not handled in the court system, it's handled by an attorney called a trustee. If the note were to ever be accelerated and the lender called it due, which a lot of people have a lot of concern around, that's not really valid in the state of Arizona, because first and foremost, it's only happened a couple times that anybody accelerated a note. When it happened, and the reason why it doesn't, and it was thrown out of court when it did back in the 80s, is that it accelerates the loan and it changes it from a note and deed of trust to a mortgage situation, which then goes from non-judicial, meaning the trustee process where an attorney handles it, to judicial, and it gets tied up in the court system here in Arizona. So when that happens, basically the lender, by accelerating the note, just bought themselves 12 to 18 months of court costs and court red tape, if you will, within the system, the legal system, and it's an ugly situation. So they end up losing a lot more money, and the homeowner gets to stay in the house, a lot longer period of time potentially. So it's a unique thing, but we're grateful here in the state of Arizona that we are a note and deed of trust state, because it makes the process of not only foreclosure in the case of trustee sale, but it facilitates a lot more functional short sales and other solutions, including reinstatement if the homeowner chooses to reinstate or has the ability to reinstate the loan. So just going through in my head here, making sure we covered everything. I think I covered a lot of material for you guys. I hope you're not overwhelmed. If I did create questions for you, please respond back. Hit us with an email below. Ask questions. We'd love to put an answer together for you. And as always, we'll respond back to you in like kind with a video so you can watch the answer versus something written to you. So we appreciate you guys watching. Just a reminder here, you can follow us on Facebook and Twitter over here on the right side of our website. Again, it's AZSSTV.com, and we're here for you, the consumer, the homeowner, the investor, even a buyer. If you've got questions around it, we'd be glad to help you. Talk to you soon.